We know that Section 73 subsection 10 of the CGST Act 2017 provides for issuance of order within 3 years from the due date of furnishing the annual return for the concerned financial year. This time limit has been extended for the financial year 17-18 up to 31st December 2023, for the financial year 18-19 up to 31st March 2024, and for the financial year 19-20 up to 30th June 2024, vide notification number 9/2023 dated 31st March 2023. The time limit for financial year 18-19 and 19-20 were further extended by notification number 56/2023 dated 31st December 2023 to 30th April 2024 and 31st August 2024 respectively. It may be noted that these notifications extending the time limits were issued under Section 168A of the CGST Act. These notifications have been under challenge in various high courts of the country so far as their validity is concerned. Before discussing the challenge pending in various high courts, let's first understand what does Section 168 holds and whether the notifications issued thereunder could be issued under this section. Section 168A empowers central government to extend time limit for taking any action under this act which cannot be completed due to force majeure. Therefore, quite clearly, this section empowers extension of time limit only in cases where department could not take action due to force majeure. Explanation to this section states that force majeure means a case of war, epidemic, flood, drought, fire, cyclone, earthquake or any other calamity caused by nature or otherwise affecting the implementation of any of the provisions of this act. Therefore, it is clear from the section itself that extension of time limit invoking this section is possible only in specified special circumstances which coincide with the description of force majeure. Now, in this context, the question arises whether there was any force majeure circumstance present at the time of issuance of notification number 9/2023 and later notification number 56/2023. An apparent answer to this question, as we all can understand and make out, is no. There was no any condition present which may fit into the description of force majeure under this section itself, enabling the government to extend the time limit. Earlier extensions were given on the pretext of COVID-19 pandemic, but even that was not prevalent when the notification number 9/2023 and 56/2023 were issued. Thus, there is hardly any justification for issuance of extension under Section 168A. Doesn't mean that provisions of Section 168A have been wrongly invoked to get back door entry, so to speak. It may also be noted that timelines for taxpayers are very strictly followed, especially when it comes to availment of ITC under Section 16(4), for which no extension was announced even during the nationwide lockdown. Law should be equal for all and should be followed in letter and spirit, meaning thereby that no provision of law should be misinterpreted or used at the whims and fancies. There is no surprise that the extension notifications have been under challenge in various high courts. Gujarat High Court has issued notice in the case of Messrs. SRSS Agro Private Limited versus Union of India. Similarly, case has been filed before the Honorable Guwahati High Court in the case of Maina Devi Chauraria versus Union of India recently. The Honorable Court has issued notice returnable on 10th of May 2024 and has observed that in view of the challenge to these notifications before various high courts, recovery proceedings, if any, vide impunged orders issued in the extension time period shall be kept in abeyance till final orders. The Honorable Allahabad High Court in the case of Graziano Transmissioni has admitted the writ petition and held that no final orders shall be passed until the matter is adjudicated by the court. So we have seen that in many high courts across the country, these notifications are under challenge, putting the resultant proceedings and assessment orders under legal scanner. Now it will be interesting to see how the high courts hold view of the matter, but having said that, it is abundantly clear that the very basis on which these notifications were issued was flawed, inasmuch as there was no force majeure present at the time of issuance of extension notifications. Stay tuned for the latest on these pending judgments. Keep visiting the channel for further updates and do subscribe the channel if not done so far. Thank you.